between a legitimate plan cancellation or cancellation of a class of policies, which certainly exists in reality as well as the law, or whether it was a cancellation based on specific claims experience and health status of certain covered members. And that would certainly raise the question of discrimination or a possible pretext, and that is where the review process would come in. That is the process that was missing, or that is missing, and more importantly, from existing law. And that is exactly the point of Ian's Law, to close this loophole or clarify this gray area in existing law, and to help both the Department of Insurance and insurance companies, as well as the consumers, to make sure that when a class of policies or a line of plans is discontinued, it is for the legitimate reasons that the insurance company can certainly set forth.
Right, and now Senator Breslin, you're smiling here.
Well,
she hit the nail on the head.
Because Susan has done a remarkably good job in explaining just what the statute does. In addition, if someone is fully disabled, like Ian, and there was a valid reason to wipe out that class, he'd still be given an additional 18 months of coverage. And there's little things. Also, as Susan alluded to earlier, there's now a private right to sue, which was very nonspecific before this time. So an individual who feels as though there was a pretext, some bad reason to cancel the insurance, that classification insurance, has the right to sue the company.
Right, but now talking about that right of action stipulation that's in there, a number of people who voted against it and the insurance companies do have a bit of a problem with that, because they're saying if frivolous lawsuits are brought against insurance companies, it puts them in a worse position to pay out legitimate claims for people who need them.
I want them to have to look at a burden. If they're doing the wrong things, that they're going to be culpable of a lot more than they realize. So I think this is an inducement for insurance companies to do the right thing.
And now the person who's going to be judging whether or not the insurance companies are doing the right thing is the insurance superintendent. Another question is, why isn't it the Attorney General? Why isn't it the Human Services Division? Why is it the insurance superintendent that you've picked out?
Well, the Department of Insurance does this every day. They're the ones that rule on the classifications. In the first instance, they deal with these situations as I said, on a daily basis. The Attorney General, I don't think, is as sophisticated or as knowledgeable, nor in fact the Health Department, to do this.
And then moving forward, when we look at this legislation, Susan, I want to ask your opinion about this too. A lot of people have questions about the impact that the federal legislation is going to have coming down the pike. What's your take on that?
Well, unfortunately, I don't think, from what I have seen and from my understanding, that federal legislation addresses this issue specifically. This is groundbreaking exactly for that reason, because this law, the introduction of Ian's Law, which we hope would be expanded across states nationwide, really is the first time this area or this scenario is addressed in any state law. And again, because this is an omission, or certainly at least absent from federal law or federal reform legislation, we look at this as a milestone and as certainly groundbreaking insurance reform legislation, starting with New York, protecting citizens of New York, and hopefully eventually protecting all Americans from the possibility of discriminatory or pretextual cancellations.
And you make a really good point there, Susan, because one of the things that the Senate Democrats and Senator Breslin, Senator Schneiderman had said going into this was they wanted this to be a model nationwide. Are you getting any indication that this insurance is going to be picked up, this law is going to be picked up?
I would be very surprised if it isn't the law in at least half the states in the next 2 years. Also, my analysis of the new federal law is this is not covered. The new federal law does away with pre-existing conditions when you get insurance. You're not allowed to deny someone because they have a condition that exists at the time the policy is given. But there is nothing, it is silent in this area. So I think our state law will continue to be the #1 law in the country, and hopefully other states will follow.
Well, moving forward, certainly breaking boundaries. And Susan, your son certainly broke a lot of boundaries when he broke this story. This is something that's been covered nationally. You've gotten a lot of support. What's just your personal reaction to how this story has been picked up and the action that you've seen?
My personal reaction, I think, is astonishment that the media was as interested as it was in a story that to us was a monumental problem, not just on a personal level. Ian certainly was the face. He was the embodiment of a catastrophic situation, a catastrophic problem. But I think what was so important was the fact that the media itself, and of course, our leadership, like Senators Schneiderman and Breslin, were able to expand the coverage and the importance, the significance of this problem beyond just a person such as Ian, who has been a groundbreaker in his own territory in his own lifetime, and take it to that next level.